Hi, my name is Carl Pearson. I'm a New York attorney, a graduate of Harvard Law School, and I spend most of my time defending against foreclosure actions taking place anywhere throughout the United States. I'm going to tell you 14 foreclosure defense facts that I believe are true most of the time, and then I'm going to identify about 82 issues that frequently arise in defending against a foreclosure or threatened foreclosure. While listening to this video, I want you to think very carefully about whether you need a lawyer at all to help you save your home and the type of lawyer you may need. Good foreclosure defense is very complicated, as you will soon learn. First of all, here are the 14 facts which I believe should be known and assumed by homeowners threatened with foreclosure. 1. You need to be represented at some point by an attorney experienced in foreclosure defense litigation. 2. This type of attorney is difficult to find and may not exist in some or many of the nation's 3,100 counties. 3. Foreclosure defense can be complicated, especially where securitization of the note and mortgage have occurred, and some of the areas of law involved are not generally practiced by most attorneys. You can't expect a law firm of 3 or more attorneys to represent you, because some of the attorneys will not want your case because they could lose legal business from financial institutions if the firm took your case. 4. There are about 100 different affirmative defenses that should be considered by the foreclosure defense attorney, and the number of counterclaims ranging from about 0 to 8. 5. Experience with loan modification applications is essential, because foreclosure defense litigation can use an affordable loan modification agreement to settle the litigation. Don't believe that free and clear is the objective of most people. It doesn't occur that way. Free and clear, winning your property absolutely free and clear, is not a realistic objective for most people. So I want to make that very clear at the outset. 6. Real estate attorneys are probably not useful for many reasons, including they tend to be transactional attorneys rather than litigating attorneys, and they seek money from banks and are less inclined to sue banks as a result. 7. Bankruptcy attorneys generally may not be needed when an attorney should first be hired, but their skills may be needed later. 8. Banks or investors in the note and mortgage are generally not desirous of entering into a loan modification agreement, which means that the bank or investor may be giving up $25,000 to $300,000 more or less in principal and interest payments over the remaining lifetime of the note and mortgage. 9. A homeowner-mortgagor represented by an experienced foreclosure defense litigation attorney is significantly more apt to obtain an affordable loan modification agreement, everything else being equal, than other homeowners seeking a loan modification agreement. 10. The cost of litigation and the possibility of an adverse decision and possible loss of the note and mortgage makes the bank more apt to give a loan modification agreement to a homeowner represented by experienced foreclosure defense counsel. 11. An experienced foreclosure defense counsel from a county or state other than the homeowner's county or state can provide legal insight and expertise, forms, consultation, advice, discovery demands, research, and affidavits in support of or in opposition to motions to enable a local attorney to be effective in his or her local representation of the homeowner-mortgagor in foreclosure defense litigation. 12. A foreclosure defense litigator from out of state can help a homeowner-mortgagor find a local attorney in the homeowner's county after analyzing the homeowner's foreclosure situation and preparing an appropriate plan for the local attorney to follow. You want somebody locally from the county because it takes money if you hire somebody from numerous counties away, say 300 miles away. They may spend an entire day of legal services or charge pretty much that in order to spend 5 minutes in court. You really can't afford that. So you need a local attorney truly from your own county or a surrounding county. 13. The costs of having two attorneys under the foregoing circumstances are necessary and essentially are not duplicative. 14. If the homeowner-mortgagor can find a local, experienced foreclosure defense litigator familiar with the many issues arising in a securitization case, the homeowner probably would spend about 20% less. That's truly a guesstimate on my part. But in many counties in the United States, such a lawyer may not exist. Now, I'm going to let you see the range of defenses and issues that can arise in foreclosure defense litigation, mainly in securitization cases where the homeowner's note and mortgage were sold to an investment pool or trust known as a REMIC trust, that is a Real Estate Mortgage Investment Corporation Trust. Here are 82 issues that can arise and should be considered when appropriate by a homeowner's foreclosure defense attorney. I'm not going to number them, I'll just once in a while give you a number so you see where we are. Who was served with a summons and complaint, and how did the service take place? Did the homeowner appear in person or through an attorney, and at what point in the litigation? Who is entitled to enforce the note? Does the note even exist? Who has standing to sue, and are there any missing parties? Who are the real parties in interest? What endorsements are on the note, or any allonge, that is an extension to the note where endorsements are added? What assignments of the note have taken place? Are any of the assignments invalid for any number of reasons? Number 10, is the holder of the note a holder in due course, or is the holder subject to the defenses which the homeowner had against the original lender? Does the note meet the requirements of the UCC for negotiability? Was the note assigned to a REMIC trust under a pooling and servicing agreement and trust agreement or trust indenture? Did the assignment to the REMIC trust occur within the time frame required for the assignment? Were there any robo-signing of assignments or endorsements? Are there any other persons claiming ownership of the note? Were there any mortgage insurance payments, and to whom? And was any credit given towards the note? Was an IRS Form 1099 issued through any cancellation of the note? Is the mortgage insurance being used as an excuse for not giving a loan modification agreement, which is paid only if the homeowner loses his or her property through foreclosure, short sale, abandonment, or deed in lieu of foreclosure? Are the note and mortgage part of the issuance of an unlawful, unregistered security under federal or state law? 20. Are there any assignments made by an attorney in fact without any accompanying power of attorney? Are there any violations of the Truth in Lending Act, TILA? Was there any failure to respond to a qualified written request? And did the qualified written request go into areas such as standing and note ownership and things like that, which the banks are generally not agreeing to provide? Were there any violations of the Real Estate Settlements Procedures Act, RESPA? Does the homeowner qualify for a HAP or HARP or in-house loan modification? Are there any new laws that have come out? Does the homeowner qualify for a principal reduction? Is there any standing among any of the agreements that the attorneys general have entered into with any of the major banks or services? Was there any assignment of the note and mortgage to Fannie Mae or Freddie Mac to avoid having to give a principal reduction to the homeowner? Does the mortgage contain a provision containing Mortgage Electronic Registration Systems, Inc., or MERS Corp., or MERS Corp. Holdings as the owner or holder of the mortgage as nominee for the lender or payee on the note? 28. Are there any assignments of the mortgage by MERS? Are there any assignments of the note by MERS? A most unusual situation, but something to look at. Are there any violations of the Federal Debt Collection Practices Act, FDCPA, or similar state legislation? Are there any governmental agencies involved in note ownership raising any issues of constitutional due process or equal protection that have been denied? 32. Were the note and mortgage sold to investors at a huge discount without giving the homeowner an opportunity to buy the note and mortgage at the same price? Is there a judgment or a default judgment that needs to be addressed through a motion to vacate? Was there any wrongful foreclosure requiring a wrongful foreclosure action? 35. Does any state mediation law deprive homeowners of their constitutional right to litigate disputes with the bank? Should you commence a quiet title action, and if so, in what court? What court is the appropriate court to go into? Federal, state, bankruptcy? There are issues that have to be decided. There are many issues in that area. 37. Do you have any debts that are precluding you from obtaining a loan modification agreement? How often can you apply for a loan modification agreement? 39. Did you waive any of your defenses or rights when you signed a trial loan modification agreement or a permanent loan modification agreement? 40. Can you use bankruptcy as part of your plan to save your home from foreclosure? What are the benefits from using Chapter 13 as opposed to Chapter 7? Can you eliminate an underwater second mortgage through bankruptcy or through litigation? What's the present value of your home? Have you heard how it may be possible to get rid of student loans through litigation? Has the bank, investor, or lender complied with various state laws relating to foreclosure? Are you able to obtain a bankruptcy attorney willing to challenge the bank's lien through appropriate adversary proceeding or motion? 47. Are you aware that any such challenge must be made within 90 days of the filing of bankruptcy, that's after the filing of bankruptcy, or that the bank's lien then becomes admitted by the debtor? Are you entitled to recovery of any payments made to someone that is not authorized to enforce the note? Are you a victim of dual-track loan modification fraud? Is your awareness of the fraud something that qualifies as newly discovered evidence to enable you to open up a prior judgment or default judgment? What oral or written agreements did you have with the loan servicer or the loan owner? Was any default in payment contrived by the bank even though you were not actually in default? Are you entitled to reformation of the note and mortgage? Are you entitled to your property free and clear? Please note that this is not something that happens very often, but could result from various situations, including but not limited to: A, failure to negotiate a loan modification agreement in good faith during a foreclosure action, or in some states prior to commencement of their non-judicial or even judicial foreclosure. B, passage of so many years after notice of acceleration of debt was given. That's a statute of limitations defense. In many states it's about 6 years. And C, dismissal of a second foreclosure action with prejudice. Those are just 3 of the possible free and clear situations, but as I said, please don't go into this thinking free and clear. 55, failure to state a claim upon which any relief may be granted, failure to state fraud with particularity, failure to attach a copy of the note and mortgage to the complaint, pleading with prolixity, thereby making it difficult to plead properly by the defendant, homeowner, unjust enrichment, accord and satisfaction, breach of implied covenant of good faith and fair dealing, breach of industry custom and usage, frustration of performance, failure of consideration, estoppel, res judicata, latches, release, waiver, unclean hands, no adequate remedy at law, failure to mitigate damages, lack of consent, mistake, unconscionability, contract of adhesion, contrary to public policy, restraint of trade, frustration of purpose, lack of privity, improper notice of breach, and finally, merger doctrine of some of the defenses and issues that arise and should be considered by an attorney defending a foreclosure action. So it is complicated, involved, far-reaching, and covers a lot of legal territory. I'm not listing all of the issues to be considered, but these are among the most obvious issues to consider, and they cover these numerous legal fields, some of which are highly specialized. I'm available to work with local attorneys to defend against foreclosures anywhere in the United States. If you have any questions, please give me a call. My telephone number in New York is 212-307-4444. That's 212-307-4444.